Good afternoon, all. My name is Nettie Fudu, and as Susan said, Suzanne and I are partners in Akin Gump's International Trade Group. We thank you for joining us this afternoon for today's discussion, and we also thank the Association for Corporate Counsel Dallas branch for inviting us. We appreciate the opportunity. As Susan mentioned, today's discussion will focus on U.S. trade policy and other developments in the first 100 days of the Biden-Harris administration. There is a lot to cover in the trade space, and the administration has been busy. However, because we don't have 5 hours for this presentation, Suzanne and I will focus on sanctions, which I will be covering, and then Suzanne will discuss tariffs and US implementation of the US-Mexico-Canada agreement. And so just to level set on what sanctions are, I assume everyone who's joining knows what sanctions are. But economic sanctions are essentially a means to an end, right? They're a tool of foreign policy intended to change behavior of the target. We use sanctions instead of waging war, as it were, not to be dramatic, but essentially it's one of the tools in our arsenal of foreign policy measures geared at getting either a country or an entity or an individual to change its behavior. It is widely assumed that the US is the only foreign power that utilizes its sanctions powers, but this is not true, right? The EU, the UK, and the UN, right, all use and enact sanctions for the same goal, right, to change behavior. And but what is true is that the US government is the most aggressive enforcer of its sanctions. So while we are not unique in implementing and utilize sanctions, we're definitely the most aggressive in the enforcement of our sanctions. We have generally 3 types of sanctions programs in the US. We have comprehensive sanctions, which essentially restrict almost all dealings with particular countries and their nationals. Right now, we have comprehensive sanctions in place against Iran, North Korea, Syria, Cuba, and Crimea. Crimea not being a country, but certainly a distinct region within Ukraine, if you ask the US, or within Russia, if you ask the Russians. In addition to comprehensive sanctions, we have list-based sanctions, which are sanctions that target specific individuals or entities. Our most well-known list of sanctions list is the specially designated nationals list. And with respect to any person or entity on that list, US persons are restricted from engaging in almost all transactions with SDNs, as they're called, in the absence of authorization from the Office of Foreign Assets Control, OFAC. OFAC, as most of you may know, is the central agency within the Department of the Treasury, which administers and enforces US sanctions. With the development of the Russia sanctions program, we've also seen a new type of sanctions program, also known as sectoral sanctions, where essentially OFAC targets specific entities within targeted sectors of a country's economy. So in the context of Russia, we have designated specific entities within the energy, finance, and defense sectors of the Russian economy. Finally, in purple, we have what are known as secondary sanctions. And I don't think of secondary sanctions as a specific type of sanctions program per se, but in respect of most of our sanctions measures, we tend to find that the US government will include language that allows us to target non-US persons who engage in particular types of conduct with respect to sanctioned persons. So understanding that our sanctions and not only our sanctions, but our laws generally have jurisdictional limitations. And so the Department of the Treasury generally cannot prohibit a non-US person from taking a specific action, especially where that action has no nexus to the United States or to a US person. And so in those instances where there's no US nexus to a particular transaction, we generally don't have the authority to say, you German national, you cannot engage in transactions with Cuba. We don't have that authority. Or you German national, you cannot engage in specific activities with Iran. But what we can do, where there's an absence of a US touch point that allows for the assertion of jurisdiction, what we can do is we say, you German national, if you provide revenue to Iran, if you buy Iran's oil, then it is in our purview to deprive you of access to the US financial system. We can impose sanctions on you that make it impossible for you to deal with the United States. And so those are secondary sanctions where we say, we certainly can't prohibit you from doing activity X, Y, or Z, but if you do, there are potential consequences. So with that background in mind, on what are sanctions and what kinds of sanctions do we generally impose, we'll move into the Biden administration's approach to US sanctions, at least as we know it today, right? So thus far, there are a couple of themes that have emerged. We are coordinating more with allies. We have seen a more multilateral approach to the imposition of sanctions. We tend to be a little bit more deliberate, so as not to be seen as acting unilaterally in all cases. Certainly, with the Trump administration, we saw a barrage of sanctions. It felt like we were sanctioning a country or an individual or an entity every other week. I mean, we were very busy. And we don't expect to see the fury and pace. I don't think we expect to see the pace that we witnessed, especially in the last couple of months of the Trump administration. But having said that, we don't expect a complete slowdown on the enactment of new sanctions. And certainly we don't expect to see a slowdown on enforcement of existing sanctions. We expect to continue to see a trend of more sophisticated sanctions that are targeted and hopefully have less collateral impact than we've seen in some instances. So we expect to see judicious use of broad sanctions, and again, more sort of smart sanctions, as we call them, more targeted. This administration so far has indicated that it has a clear focus on human rights issues, cybersecurity issues, corruption, and of course, national security is the everlasting concern that that the US generally has its eyes on. And then we've also seen the effect of COVID-19 on sanctions, really to sort of create avenues such that sanctions are not an impediment to the dissemination of COVID-19 vaccines now, but even before vaccines, there were a number of relief measures that were implemented to ensure that COVID-19 related medication and medicine were able to be exported and re-exported globally without sanctions being an impediment to movement. Next, I will talk us through sanctions developments in particular countries. There's a lot going on, but I've chosen developments, I think, that are most in the news and also perhaps most relevant for this crowd, which I think will include companies, representation by companies that are perhaps in the energy sector and perhaps construction. So First, we will discuss Myanmar, which has been in the news lately following the military coup which occurred in February. As a result of this coup, and if you recall, we have had sanctions in place against Myanmar years and years ago. And then during the Obama administration, those sanctions were largely terminated because of the successful election of Aung San Suu Kyi. And then in February, there was another election, and she appeared to be the elected winner. However, the opposition challenged her win, and subsequently the military took over. For now, the sanctions are limited. We've imposed sanctions on particular military officials, as well as particular military owned or controlled holding companies. There is certainly room to expand on sanctions, and there is a feeling that if Myanmar continues, or if the military continues down this path, especially if they continue to hold certain political dissidents in prison, that there is certainly an appetite to expand sanctions. And faithful to this idea of the US working with its allies and sort of taking a multilateral approach to sanctions, the US is not alone in the sanctions that it's imposed to date. And we've seen sanctions also imposed by the EU and the UK. And we've sort of, again, taken a coordinated approach in the actions to date with respect to Myanmar. So from Myanmar, we go to Russia. Russia has been in the news a lot lately. In fact, Russia has been in the news very prominently since the beginning, or even slightly before the beginning of the prior administration. And Russia continues to be in the news, right? So following his inauguration in January, President Biden tasked the US intelligence community with reviewing various Russian malign conduct, including the extent of Russian interference in the 2020 election, the poisoning, arrest, and jailing of Russian opposition leader Alexei Navalny, reports of Russian bounties on US soldiers in Afghanistan, and most recently, the SolarWinds cybersecurity intrusion. As a result of this review, the Biden administration found that the Russian government used a chemical weapon against its own national, Mr. Navalny. And as a result, we have imposed a slew of sanctions under the Chemical Weapons Conventions Act. A lot of the sanctions we've imposed are more of a export controls related nature, but we've also imposed sanctions on particular entities and individuals in Russia who are deemed to have been involved in the poisoning of Mr. Navalny. Also, as a result of this review by the intelligence community and the identification of various, as we've called them, specified harmful foreign activities that have been engaged in by the Russian Federation, just last week, on the 15th, President Biden issued a new executive order, which the administration has described as a sweeping new sanctions authority, right? Among other things, this new executive order authorizes the administration to impose new sovereign debt restrictions. Previously, US financial institutions were prohibited from engaging in the primary market for non-ruble denominated bonds. But following the executive order issued last week, now US financial institutions are prohibited from engaging in the participation in the primary market for ruble and non-ruble denominated bonds issued after June 14, 2021 by the Central Bank of Russia, the National Wealth Fund of Russia, and the Russian Federation. In addition to the sovereign debt restrictions, the US government now has broad authority to impose blocking sanctions on persons that operate in various sectors of the Russian economy, including notably the technology sector. Pursuant to this executive order, we've also imposed sanctions on over 30 individuals and entities that the US government determined to have played a role in influencing the 2020 presidential election or engaging in malign cyber activities. We've also imposed sanctions on individuals and entities associated with the ongoing military buildup in Ukraine and Crimea. I think what is clear with respect to Russia is that, number one, the US government views, and I think most people agree, that since 2018, where we saw the sanctioning of major Russian oligarchs, these sanctions measures are the most significant imposed on Russia in several years, and certainly a signal that the Biden administration is prepared to impose additional sanctions in the future in response to various Russian malign activities. Last week, when the EO was issued, President Biden said, the United States could have gone further, but chose to be proportionate in these actions. And with reports that, Russia is building up, like I said, military capability in Crimea and around Ukraine, with Navalny's health deteriorating in Russian prison, and the controversial Nord Stream 2 pipeline, which I will discuss shortly, between Russia and Germany, almost complete. I mean, we are certainly imploring US and non-US companies to keep a close eye on these developments, because there could be impact for their business as the Russia landscape continues to evolve. I will speak just very briefly on Nord Stream 2. As some of you may know, the Nord Stream 2 pipeline is a gas pipeline under construction that is intended to bring natural gas from Russia to Europe through Germany. And construction is almost done. And I believe, whether the US likes it or not, my view is that this pipeline will be completed. The Russians will likely have to get creative, but the US, through legislation, continues to threaten and to impose, to some degree, sanctions on non-US companies who assist Russia in completing this pipeline. However, given that it's almost 95% done, my expectation is that, notwithstanding our view that this is bad for Europe, this pipeline will be completed. Nonetheless, non-US companies, a lot of European companies have actually backed out. And to the extent that there are still companies who are involved in helping with completion of construction of this pipeline, they certainly risk for sanctions. Both Congress, I would say, is unified in viewing this as a top priority for the US government, and as such, there is real risk for non-US persons who are involved. So moving from Russia to China, similar to the Trump administration, I mean, I would say that with Russia, there was certainly a feeling after the 2018 sanctions that we took we were not as aggressive in imposing sanctions on Russia. But unlike Russia, with respect to China, there is a feeling, and I think we're seeing this already, that the Trump administration and the Biden administration and Congress are unified in viewing China as a national security threat on a number of fronts, right? Including its actions in Hong Kong to crack down on pro-democracy activists, and certainly significantly diminishing Hong Kong's authority. We continue to have concerns about China's military civil fusion activities, the potential diversion of US equipment and technology into China's military program, as well as the age-old concern about theft of US intellectual property and technology to advance China's technological development. So as a result of all of these concerns, there were a barrage of sanctions imposed on Chinese companies and Chinese individuals. And we saw some new types of sanctions, including in particular, the Communist Chinese military companies sanctions. These were a new type of sanctions program where essentially US persons were prohibited from purchasing or selling for value publicly traded securities of identified Communist Chinese military companies. I can tell you that I spent a lot of time with my colleagues in our securities group trying to understand what this exactly meant, right? What are publicly traded securities? What is a security? You know, what does purchase for value or sale for value mean? How do we interpret the scope of exemptions from this new set of sanctions? And I think we've largely got our hands around it. But what I can say is that while the Biden administration seems to be in tune with the Trump administration in terms of China and being tough with China, a lot of people had hoped that the CCMC sanctions would be terminated because they seemed a bit abrupt in the way that they were imposed and the way that they've been administered. And there's been a lot of confusion around it. And so that there'd been the hope and expectation of some that these particular sanctions would be terminated. But so far, this executive order is still on the books. We know that the Treasury Department is conducting a top to bottom review of US sanctions, but the status of this particular program, while it has been somewhat modified during these initial days of the Biden administration, it's certainly still law. And so these sanctions are still on the books. There has been recent litigation by some companies that were targeted by CCMC sanctions. Xiaomi, for example, was successful in getting a preliminary injunction put in place, arguing that its addition to the CCMC list, as well as the imposition of these publicly traded securities related sanctions, were a violation of its due process rights. And the court upheld the motion, and right now there's a preliminary injunction in place. Remains to be seen if the U.S. government will appeal or simply proceed rather to summary judgment. Another company that's currently on the list, Lukwang Technology, has also challenged its addition to the CCMC list and the imposition of the related sanctions, and we are waiting to see if it will be similarly successful or not. In addition to US national security concerns regarding China, forced labor and human rights concerns, especially in Xinjiang, generally has been a policy focus of the Trump and Biden administrations. And we've seen restrictions from a number of angles and a number of agencies, right? CBP has issued withhold release orders. The Department of Commerce has added a number of Chinese companies to its entity list. OFAC has imposed sanctions on XPCC and other entities in Xinjiang. And there's legislation in Congress, right? There's the Uyghur Forced Labor Prevention Act. This entire area is one where we've seen a unified front in Congress. We've seen global coordinated measures from the UK, the EU, and Canada, who have also announced asset freezes against senior officials who've been accused of serious human rights violations. And as China continues to dig in, especially in this area, it is my expectation that we will likely see expansion of sanctions in this area, and not just sanctions, but other trade restrictions. Moving on to the next slide. So other notable sanctions developments, not much has happened with Venezuela, except that it seems that the Biden administration will continue the Venezuela sanctions that were imposed under the prior administration. This administration continues to recognize opposition leader Juan Guaido as Venezuela's rightful leader. So it is unlikely that we will see a lifting of the Trump era sanctions, at least in the short term. With respect to Iran, the US is currently in discussions regarding the Joint Comprehensive Plan of Action, the Iran nuclear deal, to see if that will be resuscitated. My personal view is that Iran would have to sort of put up quite a bit for the US and make some changes and sort of show a demonstration of good faith in order for us to resume the Joint Comprehensive Plan of Action. We've seen a complete reversal of sanctions that were imposed on the International Criminal Court. Most sanctions practitioners found that to be quite ludicrous. And so it's not surprising that the Biden administration has terminated the executive order imposing sanctions on the International Criminal Court. And then final slide on sanctions, Belarus. I'm not a huge economy, but I mentioned Belarus only because the Belneftekhim, which is the main petrochemical company in Belarus, engages in transactions with a number of US oil majors. However, Belneftekhim was designated as an SDN back in the early 2000s. And then beginning in 2015, when Belarus freed certain political prisoners, the US government issued a general license that allowed US persons to engage in transactions with Belneftekhim and 8 other state-owned entities. However, as some of you may know, last year, the president of Belarus won yet another election, which the Belarusians, essentially their position is that it was rigged and that he should not have won. And in response, there were a number of demonstrations, and the president in turn essentially imprisoned about 340 dissidents. The US government has requested that these political prisoners be freed. Belarus has refused. And as a result, yesterday, the US government revoked the general license that had been in place since 2015, allowing US companies to engage in transactions with 9 Belarus state-owned entities and their 50% or more owned subsidiaries. And so effective yesterday, US companies can no longer engage in transactions with Belneftekhim and the other SOEs that are affected by the revocation of the general license. Having said that, US companies do have 45 days up until early June to engage in wind down transactions with respect to the relevant state-owned entities. And with that, I'll pass it on to Suzanne to take us through the balance of the slides.
Thank you, Nettie. So my name is Suzanne Kane. I am a partner at Akin Gump in the international trade practice with Nettie, and my focus is on US imports. So I'm going to go over Where we are with some of the developments in U.S. tariff policy, the implementation of the USMCA, which is kind of our new NAFTA or NAFTA 2.0, and some other trade policy developments that in fact can have a very large impact on imports into the United States, and those are primarily related to some of the China policy that Nettie set up for us earlier. So starting on with perhaps the broadest tariffs or the tariffs that affect the broadest number of industries and importers are Section 301 tariffs on products of China. And these were implemented by the Trump administration after an investigation under Section 301 of the Trade Act into China's policies on technology transfers and intellectual property rights. And that investigation concluded that China's policies, among many other conclusions, but primarily that they burden and restrict US commerce. And the Trump administration's response to that investigation was to implement tariffs on a broad range of products from China in essentially 4 tranches. So the tariffs were implemented on list 1 first, then list 2 of products, then list 3 of products, and list 4A of products. So we have 4 tranches of products that are subject to primarily 25% extra tariffs when they're imported into the United States. There are some products on list 4A that are subject to just 7.5% tariffs now, but those are still having a very large impact on US importers. During the Trump administration, USTR, after it implemented these tariffs, it also allowed for a finite exclusion process where importers could apply for an exclusion from the tariffs if they could show that the product wasn't available anywhere else in the United States, and also that they were making progress towards moving their supply chains away from China. And that exclusion process under USTR was one time only. It is now closed, and all of the exclusions have now expired. And so we've been watching the Biden administration very carefully to see how they are going to handle these tariffs, these Section 301 tariffs, as we go forward, as well as whether they might be open to reopening the exclusion processes or even implementing them on an ongoing and rolling basis. And what we've seen so far is that the Biden administration did extend a very narrow subset of exclusions from these 301 tariffs for COVID-related products, or COVID-related response products or medical products used to help treat patients during the pandemic. So that is promising and indicates that the administration is open to finding some solutions to some of the hardships that these tariffs cause for importers. However, the Biden administration has indicated so far that they do view these tariffs as important leverage against China right now, and that while they are reviewing them from top to bottom, that they don't intend to roll them back at least anytime soon. Some things to keep in mind, since we now anticipate that the tariffs will stay in place at least for the near future, for the large part, is that importers should still be very aware that this is a very large area of enforcement for U.S. Customs and Border Protection. And it is very important to know that even if you do not import products directly from China, you may still be importing Chinese origin products from other countries if your products have major components that are sourced from China, or major manufacturing steps were undertaken in China. And the reason we bring this up is that this is a very large focus of enforcement from customs, and we see importers receive many requests for information from the government about where their products were produced and the processes that the manufacturing processes that are conducted in the countries before importation into the United States. One change in the past year about these tariffs is, or excuse me, not a change, but the Hong Kong origin goods, if you import goods that are produced in Hong Kong, they are not subject to the 301 tariffs, even though in the last year, the rules for product marking on products of Hong Kong did change. So now products that are produced in Hong Kong must be marked physically with that their origin is China, even though those goods are not subject to the 301 tariffs. And so we do expect, as these tariffs stay in place, as USTR reviews them, we do expect continued enforcement from US Customs around these tariffs. And as I mentioned, primarily around questions to importers about the country of origin of the goods, but also whether the valuation of the goods is correct, meaning whether the amount that the tariffs are assessed on is the true value of the goods and that they're not undervalued. And this is particularly the case where US Customs senses a change in your import patterns. So if an importer, even if you change where you're sourcing from and you imported the same widget for many years from China, but you change your supply chain to Thailand or elsewhere, Customs is often notices these changes and often requests information about to support the change in reporting to Customs. So these are just things to be aware of. They're very common, but they're important to be prepared for if you get questions from the government. So as I mentioned, the Biden administration has indicated that at least for now, these will stay in place as they continue to negotiate with China. One thing to watch for, though, is importers have started to take to challenge the 301 tariffs in court at the Court of International Trade, and this is the legal challenges so far are limited to the implementation of tariffs on list 3 and list 4A of products that are subject to the goods. So the lawsuits do not yet address products covered by list 1 and 2 of the 301 tariffs. But essentially, there have been about the largest lawsuits that the Court of International Trade has ever seen, about 3,700 complaints covering about 5,000 importers, alleging that the list 3 and list 4A tariffs were implemented outside of the timeline authorized by the Section 301 statute. So this lawsuit is going on right now, and is actually just started to really pick up speed with a scheduling motion set. So this is something that we're watching, well, we're participating in, but many importers are also watching very closely. If you do import things, any items that are covered by list 3 or list 4A of the tariffs, you may want to consider joining the lawsuit. The statute of limitations is certainly not run on list 4A products until about August 20th or so. And some of the statute may have run on certain entries for list 3 products, but there's still probably an opportunity to recover tariffs paid on list 3 products as well, if you're considering joining the lawsuit. So moving to kind of a more narrow subset of tariffs, but very, very important one that affects a large number of importers and industries very acutely, is the Section 232 tariffs on steel and aluminum products. And these products are implemented by Commerce as opposed to 301 tariffs, which are implemented by USTR. And the premise of these tariffs is that the Commerce did an investigation and determined that imports of these steel and aluminum products threaten the national security of the United States. And the rationale there is that these imports threaten the economic security of these domestic industries, and therefore making the United States continually increasingly reliant on foreign sources of steel and aluminum, and that in turn affects our national security. So in March 2018, President Trump imposed 25% tariffs on steel products and 10% tariffs on aluminum products from certain countries. And one big difference here between the Section 232 tariffs and the 301 tariffs is that the Section 232 tariffs are the government has implemented them on a country by country basis. So there are several special arrangements that reflect the foreign policy with that country. So for example, Canada and Mexico are now both exempt from the Section 232 tariffs under certain conditions that were negotiated alongside the USMCA. Brazil and South Korea negotiated quotas on their steel products instead of the tariffs. So if you import from Brazil, steel products from Brazil and South Korea, you have to make sure there's still room under the quota, but you don't pay additional tariffs on those products. Argentina, in contrast, has absolute quotas on both the steel and aluminum, products, and Australia is exempt from tariffs and quotas on imports of steel and aluminum products. And as a result of these tariffs, these have been very inflammatory with a lot of our trading partners, and many of our trading partners have, especially the EU, have implemented retaliatory tariffs that have been very, very painful for some US exporters to those countries. So what's new with the Section 232 tariffs? We've seen a lot of criticism, especially from Congress and from importers, about the Commerce's exclusion process for Section 232 tariffs. So importers can apply to the Bureau of Industry and Security for an exclusion from these tariffs for very particular goods and specific to a particular importer if they can show that the domestic industry cannot provide the product and that they have no ability to source the product in the United States. This process has been rife with problems, delays, lack of transparency. And so Commerce recently, in an attempt to help streamline and clean this up, at the end of last year, implemented a new process for generally approved exclusions. So these are new exclusions that don't have an expiration date. They're available to all importers. And they're not subject to any quantity limitations like the normal exclusions are. And the new Secretary of Commerce, Gina Raimondo, said this week in an interview that she is focused on streamlining this process and making sure that it is more transparent and friendly to importers as well. What else is new with these tariffs is two surprisingly successful legal challenges at the Court of International Trade. Earlier this year, we had the Trans-Pacific case where the Court of International Trade held that the Trump administration's increase of 25% to 50% tariffs on imports from Turkey was outside the power of the executive branch, which was a big win for those importers. And then just at the beginning of April, the Court of International Trade held that the extension of these tariffs to certain derivative products was also outside the timeline authorized by the statute, and therefore those tariffs were, the tariffs on those derivative products were no longer valid and need to be refunded. And then there have been a number of challenges of the 232 tariffs at the WTO, brought by China, India, Norway, Russia, Switzerland, Turkey, and the EU. And those decisions by the WTO panel on those cases has been delayed because of many delays at the WTO to later this year, but is a good indication of how contentious these tariffs are. So we do know that the Biden administration is reviewing these Section 232 tariffs. We understand that they are reviewing them on a country by country basis, as opposed to the tariffs as a whole. But the Biden administration has been more surprisingly positive about these tariffs, more so than I think we expected, and that's because of the support that it gives to domestic industries and labor. Again, Gina Raimondo said just this month that these tariffs have helped save American jobs in the steel and aluminum industries. So we anticipate that they will not be lifted anytime soon, but we're optimistic that a country by country review may lead to some, perhaps some lifting or at least lessening of some of these tariffs. So this is just, I realize we're getting close to the end of the hour, but this is just a quick list of kind of strategies that we use as counsel to importers to help if you are importing items that are subject to these tariffs and they can have a very large impact on your bottom line. These are just some strategies that we use to try and mitigate the impact of those tariffs, whether it's by confirming whether your goods could be the product of a different country, maybe not China, for purposes of the Section 301 tariffs, whether there's a legitimate way to lower the value you declare to U.S. Customs for your goods, and therefore lower the amount of tariffs that you're paying, whether there might be some special duty-free provisions that apply to your goods if there's certain medical goods or U.S. goods returned. You know, there's a number of ways to get creative with some of the special duty-free provisions that are available. And then the use of foreign trade zones, bonded warehouses as a way to defer at least defer some of these tariffs until later, or if perhaps you may export the goods. And we're, of course, available to talk about any of these strategies in more detail and how they might apply. So another big area that is that impacts U.S. imports is the implementation of the USMCA, the United States Mexico Canada Agreement, which is basically our replacement of NAFTA or updating of NAFTA. The USMCA was entered into force last year in July 1st. That was a very fast implementation for a lot of importers, and as a result, U.S. Customs, who enforces the trade agreement, gave or implemented what they call a period of restrained enforcement, where they were allowing importers to get up to speed with the rules of origin, to get up to speed with the processes or the simplified processes in this agreement. However, that period of restrained enforcement ended at the end of last year, and now we are in kind of our normal period of enforcement of the USMCA. So last year we had some minor technical fixes to the USMCA to correct some drafting errors, but by and large, the text of the agreement and the rules of origin are set, with one very large area of uncertainty around certain rules, certain regional value content rules for the automotive industry, which is a source of some disagreement between Canada, Mexico, and the US right now over the interpretation of the rules in the text. And so that is playing out right now, but besides that disagreement, the text and the rules of origin in the text are set. So the USMCA is very similar in many aspects to NAFTA, although there are some simplified processes. One thing to note is if you did rely on NAFTA for duty-free treatment, and you are planning to rely on the USMCA for similar treatment, is to confirm that the rules of origin either haven't changed, or if they've changed, how that might impact you. But also, if you rely on any customs rulings or administrative binding decisions on the USMCA eligibility of your goods, those unfortunately are you can no longer rely on those. You would have to request a new ruling from customs on the new fact pattern under the USMCA rules. So that is an unfortunate fact that we learned from customs in the past 6 months, but it does make sense since these are new rules of origin. And the other thing to note about the USMCA, which is one very big change, is that the USMCA has a completely new approach to the settlement of labor disputes called the Facility-Specific Rapid Response Labor Mechanism. And under this mechanism, both US and Canada can request an international arbitral panel to quickly determine whether a Mexican facility in certain priority sectors is in compliance with Mexico's reformed labor laws. And the big impact or potential impact of this on US imports is that panel can stop imports from that facility while the investigation is ongoing. So if you happen to source from a facility that becomes the subject of an allegation, then that can hugely impact your supply chain if that facility is not allowed to send goods to the United States while the investigation is ongoing. U.S. policy here is very aligned, bipartisan. We're aligned with many other countries around the world, but there's a big focus on sanctioning China, and especially imports from the XUAR, where there is tons of evidence of forced labor being used to produce goods. And so far, CBP has issued several import bans on goods from the region. Most of those bans were specific to particular producers or manufacturers. But just in January, they issued a region-wide WRO, which is essentially what's called a withhold release order, but essentially means an import ban on any cotton and tomato products from the region. And we anticipate that there are probably more WROs coming from CBP on imports from the region, perhaps most likely on solar panels next, or perhaps even a ban on all goods from the region. And as Nettie also mentioned, this is in parallel with an effort in Congress to pursue very far-reaching legislation under the Uyghur Forced Labor Prevention Act that would essentially ban all imports of goods produced in the region. produced in the region or produced with any inputs from the region too. So that would be a very, very large import ban that would have an extremely large impact on a lot of sectors and importers. So I will wrap up there. Thank you so much for this opportunity, and thank you for listening to us this hour.